We have a presentation by Mr. Brian Kane from the Attorney General's office on the open meeting law in Idaho. So he's going to give you a presentation on this, and you have a book in front of you, just a manual put out by the Attorney General's office, and giving you the basics of what is required in the open meeting laws. And I thought this would be helpful just as a reminder what the law says and what the rules are regarding open meetings in Idaho. So, Mr. Kane.
Good morning, Mr. Kane. Thank you for joining us.
Morning. Thank you, Mr. Chairman. My name is Brian Kane with the Attorney General's office. I have been asked to come here to present on the open meeting law. And just so you all know, this training that you're going to be given is the same training that we give across the state. It's training that's delivered to boards such as yourself. It's delivered to the public, meaning constituents, and it's also delivered to the press. And we have found that to be of great benefit, because when we get asked a question or you get asked a question regarding the open meetings law, guess what? Everybody has received the same information and the answers are the same, which makes for a lot smoother sailing, at least in our experience. With that, I will take you through the open meeting law and a couple of what we see as potential sticky spots in it. And I think that, you know, in any sort of endeavor within government, sometimes government is more cumbersome than it is in our everyday life. And the open meeting law certainly has those spots, but there's a reason for why it's a little bit more cumbersome, and it's in order to allow for transparency and oversight. The open meeting law, in simplest terms, is the public's ticket to the show being government. And just so you know, within the last year, the Idaho legislature recodified the open meetings law, the ethics in government law, and the public records law. We also have a manual for that. And put them all under the same title, Title 74. And I think that was a very important move for the state of Idaho, because previously, here's a trivia question for you. Does anybody know what title of the Idaho Code the open meeting law used to be in? I'll give you a hint. It's my favorite title of the code. We had a title in the code in Title 67. It's still there. It's called miscellaneous. And in essence, we have no idea where these statutes should go, but we're going to put them all under this one. And it was actually wedged in there right in the middle of all the miscellaneous statutes. And so the legislature, I think, wisely pulled it out and said, here is the open meeting law, and put it together as Chapter 2 of Title 74. And Title 74 is now titled Open and Transparent Government, and that's why you've got Chapter 1 is the Public Records Law, Chapter 2 is the Open Meetings Law, and then the Ethics in Government Law follows in Chapters 3 and 4. So I think that that's an important change. The starting point for the open meeting law is that the policy of the state is that the formation of policy is public business and shall not be conducted in secret. And I always think that's a great starting point, because whenever you as a board are thinking, should we or should we not have an open meeting law, this to me is the guiding premise. And the answer is, we should do it in the open. And one of the things that we say within our manual is, when in doubt, open up the meeting. We counsel boards and government officials regularly that if they are trying to avoid application of the open meeting law, then they have failed this overarching public purpose. And we call it the trusteeship of public office, the fact that the public has trusted you to represent them and make decisions for them, and therefore you have a responsibility to provide a transparent process by which they can oversee it. And this all works together through that system. We're going to go through some definitions, the notice and agenda requirements of the meeting, how the meeting is conducted, executive sessions, and then enforcement. If you stick with me for the first four, you should have no problems on enforcement. As a creature of statutory construction, one thing that I have to always caution you on is that the legislature gets to make the rules here. Meaning, if the legislature tells us that if it quacks, waddles, has a beak, flies, swims, and it's a dog, guess what it is for us? It's a dog. And sometimes that can be a little difficult, because you look at a definition and you think, that's not what I learned when I was in school. Well, that's why it pays to be a legislator. You get to make those rules. So we start out with a decision. And a decision is any determination, action, vote, or final resolution which a vote of a governing body is required at any meeting which a quorum is present. That's a fairly tight definition. That definition, however, is expanded by the very next one, which is deliberation. And that's the receipt or exchange of information relating to a decision, but shall not include informal or impromptu discussions of a general nature. I like to define that as the road to a decision. So if you know that there is a decision on your horizon and you're exchanging information related to that decision, then that comes under the open meeting law. The key there is the quorum. You have to have a quorum present. Now, you can create a quorum without realizing you've created a quorum. So for example, I see that you have 5 commissioners. Are you?
I'm not a commissioner.
Not a commissioner, okay. You have 5 commissioners, which means a quorum is 3 folks. And so if Chairman Beck goes to Vice Chairman Chipman and discusses an issue, that doesn't create a quorum. But if Vice Chairman Chipman goes to Commissioner Clausen and discusses the same issue, guess what's just been created? The quorum, because you've exchanged information among 3 of the 5 commissioners. And that's what we call in our office a serial meeting. And it's very easy to do because of how informal. One of the easiest ways to do it is actually through email. A super easy way to violate the open meeting law through email is through which button? Anybody know?
Reply all. I've attended your lectures before.
Gold star for Vice Chairman Chipman. Reply all is the enemy. And you can see how that happens. And so one of the things that we often recommend when staff is sending out emails to a commission such as yourself is that you never reply all, and if you have questions or inquiries, all of those inquiries are directed back to staff, not to each other. And that's so that you don't run afoul of that serial meeting and that quorum prohibitions within the open meeting law. Just good things to kind of keep in mind. The other question that comes up with regard to this is, can we as a board go to lunch? And the answer to that question is absolutely. You absolutely can go to lunch together. The caveat, the caution, is that you can't talk shop at lunch. And that may sound easy, but it's important to understand what it is that you have in common. And I will demonstrate this with an example. I am an attorney, and so when I go to social events, I wind up talking to other attorneys most often, probably because we're the only folks that can stand each other. And we always have a fairly predictable conversation on it. We start talking about family, vacations, maybe a movie or a book that we've read, and then we get to what I call the awkward pause. What do we talk about next? Of course, this predictable conversation may be why I don't have more friends as well. But whenever you get to that awkward pause, 2 things can happen. You either excuse yourself and freshen your drink or find someone else to talk to, or you start talking about the thing you have in common. And so for me, what is the thing that I'm going to have in common with another attorney? The law. For you all, what's the thing that's most likely in common with each of you when you get to that moment? The business of this board. And so the question isn't, can you go to lunch together? The question is actually, do you have the self-discipline to go to lunch together and not talk about shop sorts of things? And for everybody, that answer is different. So the answer is, yep, absolutely you can go to lunch together. The caution is, be aware of what happens when you do go to lunch together. I'm not going to go through the definition of public agency because you clearly fall under it. I am, however, going to highlight the last sentence, or the last line on this. Any sub-agency of a public agency created by or pursuant to statute, ordinance, or other legislative act. In other words, if you create a subcommittee that's going to then make a recommendation to your board, that subcommittee should comply with the open meetings law, because that builds in the deliberation towards that decision. Governing body, you meet the definition of that. You have 2 types of meeting, regular and special. A regular meeting, you have to provide at least 5 calendar day meeting notice and 48-hour agenda notice. And then special meetings shall not be held without at least 24-hour meeting and agenda unless an emergency exists. We get asked all the time, what's an emergency? Our definition of an emergency is the fire is marching down the hillside, the floodwaters are rising. There is a reason why you can't provide 24 hours notice. It's not, we forgot about it. You can also have a meeting that is only an executive session. And for that, you have to, again, provide 24-hour meeting notice, and it has to state the reason and specific provision of law authorizing the executive session. And so when we get to that portion, you'll see that there are specific exceptions for executive sessions. You have to annotate which one of those exceptions you're going in under. Every meeting requires an agenda, and in looking at your agenda so far, it looks pretty good to me. It looks actually modeled after the land board agendas, which are also very well done. They are posted the same as meeting notice. You can have amendments to agendas. A motion and vote is required for amendments made within 48 hours of the meeting. We actually went through the amendment process yesterday in the Board of Examiners meeting. And that was actually a good refresher for that board on how to go through that process. And what had happened that required the amendment to the agenda was we received a cost bill the day before the meeting. But it was a cost that has to be paid by the legislature, and so it requires a legislative appropriation. And so the claim had to be approved by the Board of Examiners before it could get approved by the legislature. And if it didn't get approved at that meeting, we would have to wait an entire another year or hope that the legislature stayed through April. So we rolled the dice and approved it yesterday. And I feel like people generally support that movement. An agenda should include all items of probable discussion. And that includes decision points. If you're going to have a decision point, that should be reflected within the agenda. It's posted at the principal office of the entity, or if you're an entity that doesn't have a headquarters office, it's posted where you're going to have the meeting. Folks ask us all the time, can we post it on the internet? Absolutely. But you still have to post it in those two spots. The internet is above and beyond. And I wouldn't be surprised if at some point in the near future, the internet is addressed as a posting point, but it has not been reflected in the law to this point. So if you're already doing it, that's awesome, keep doing it. Just make sure you get it also posted in accordance with the law. All meetings are open to the public. You can't hold a meeting any place where there's discrimination on the basis of race, creed, color, sex, age, or national origin. A couple of places that these occur, if you guys, if your board decides to go out and hold meetings, for example, around the state, things to always be aware of is that sometimes folks want to have meetings in churches. It's always worth evaluating whether or not folks consider that to be a place that's open, because sometimes folks are uncomfortable going into other churches. The other thing that happens in Idaho, because we're a small state, sometimes with smaller towns and commissions, is folks want to have meetings within houses. And again, you run into that same question of, is that actually a place that's open to the public, and do folks feel comfortable going there? And so just things to think about if you decide to take the board on the road around the state. You can conduct meetings using telecommunication devices. The requirement is that you have to have a central location where folks can listen or observe the meeting. So for example, if you were going to have this by teleconference, you'd have a speaker here and then either the executive director or a member of the board in the room, so folks know this is the place and they don't just come into an empty room with a speaker like some science fiction movie. And then you just have to make sure everybody can hear. Or if you're going to do, we've had folks say, can we do a meeting via GoToMeeting or Skype or something? And the answer is absolutely. Just make sure you have somewhere that can project, you know, all the folks that are participating in the meeting. This room would be great for it because you could see that all projected up there. Those are the requirements for that. That being said, you can't text or use computers to message back and forth during the meeting because that defeats the very purpose of the open meeting law. And you all don't suffer from this, but I've also seen boards where folks come into a meeting and they're greeted by what I call the wall of screens, meaning all they see are a series of these laptop backs. And just I always like to remind folks that it is the public's opportunity to come down on issues that they care deeply about with folks that represent them. And so they do want to see the folks that are making these decisions and not just be greeted with that wall of screens. I think of government at times as a customer service business. To me, that's one of those important customer service elements. You do have to provide written minutes. And in case you're wondering, written minutes means that those minutes have to be in writing. You're probably wondering why I would point that out to you. We actually took a case all the way to the Idaho Supreme Court on that point, where folks argued that written could be an audio recording of the meeting, and we said, no, written means in writing on paper. The Supreme Court agreed with our interpretation. So in case you were fuzzy on that concept, I'm here to clarify. Two things with written minutes. Number one, minutes are a public record. Number two, draft minutes are a public record. And so just because you have a draft of the minutes and they haven't been approved by the board, those are still a matter of public record and have to be disclosed. We recommend that they be stamped with draft, and that you may even want to put something on there that they're subject to change based on the action of the board. They have to be available within a reasonable time afterwards. I have no definition of reasonable. I take it to the sophistication of the board. If you're a board that meets every day, then your minutes should be coming out pretty quickly, probably every day. If you're a board that meets once a week, then each week those minutes should be coming out. If you're a board that has good staffing, the minutes should come out more quickly than a board that has like a part-time clerk or something. And so reasonableness is going to depend on how the board operates. The minutes have to include all members present, motions, resolutions, and disposition, and the results of all votes. Under the open meeting law, you can go into executive sessions. The executive session can only be gone into based on the exceptions contained within the open meeting law. The motion has to identify the specific subsection authorizing it. There's a roll call vote on the motion, and then that vote is recorded within the minutes. An executive session is authorized by a 2/3 vote of a governing body. So, quick math quiz. You are a 5-member board. How many votes do you need to go into an executive session? A+. You're all right. 4 votes. For a quorum, it's 3, but you need 4 votes to go into an executive session. A couple of things with executive sessions. Number one, as a practice point.
Chair, if I'm going to ask a question, so let's say we only have 3 board members here, then they could never go into executive session.
That would be my recommendation, that they not go into executive session. And it's because it says, if you look at that last sentence, 2/3 vote of the governing body. And it's not of the quorum or those present. And so I always like to make sure folks see that distinction there. And I think that there are a couple of reasons for it. Number one, executive session should be used sparingly. Number two, when you go into executive session, it's worth considering whether or not you reflect within your minutes the time that you went into the executive session and the time that you exited. And again, that's one of those measures that you can take to instill confidence in what you're doing as a board. If you as a board go into an executive session to discuss, for example, acquiring a piece of real estate, and you go in and you discuss it for 25 minutes, well, that sounds reasonable for what it would take to discuss the acquisition of a piece of real estate. If you go into an executive session and it takes you 3.5 hours over a piece of real estate, folks are going to start asking questions. You know, did you really discuss that piece of real estate for that long? And I think those are fair questions, and one of the ways to build that confidence is to reflect when you go in and when you come out. It also is very helpful if you have to go in for more than one reason. So for example, say you're going into an executive session for the hiring of an employee, and then you're also going to discuss a piece of real estate, and then you're going to have a discussion with your legal counsel. Well, within your minutes, you can reflect at 3:51 p.m. we went in to discuss the hiring of employee. At 4:02, we finished discussion of the hiring of employee and began discussion of can you remember what my examples are? Oh, the real estate. And then at 4:25, we finished discussion of the real estate and entered into the discussion with our attorney regarding litigation. And then at 4:35, we exited the executive session. But what you do is you haven't disclosed any information about what you discussed in the executive session, but you've given the public a nice roadmap of how your meeting progressed, and it instills confidence within that process. So it's just a practice thing to consider when you do it. The other thing, the other reason why I will advise you to use executive session sparingly is, does anybody know what Ben Franklin said about secrets? The only way you keep a secret among 3 people is if 2 of them are dead. And I think that there is a lot of truth to that, because one of the questions we often get asked is, who gets to come into an executive session? And the answer is the board decides. But just from a human common sense point of view, the more people you bring into an executive session, the less likely that that confidence is going to be preserved. Similarly, if you discuss a lot of things in executive session, well, now you've got a lot more things to keep confidential. And so just from a human practical standpoint, it becomes much more difficult to keep those confidences. And so just things to consider as you evaluate executive sessions. These are the exceptions for executive sessions. One of the things that I want to call your attention to is that as you go through each of these exceptions, you will notice that there is always a specific object or person that you can identify within each executive session. And so if you're evaluating whether or not you should have an executive session and it's for a general something, the answer is probably not. If you can point to a specific person or object within the executive session that you're going to discuss, then it's probably okay. And I'll demonstrate it as I go through these. When hiring a public officer or employee, the respective qualities are to be evaluated to fill a particular vacancy. So there you should say, we're filling X vacancy. That's your specific object. The next one, evaluation dismissal. We're considering the evaluation of X employee or X public officer. To acquire an interest in real property, X parcel. Consider records. This is the record that we're considering. Preliminary negotiations. This is the negotiation we're evaluating. Legal counsel for a public agency for pending litigation or controversies not yet being litigated. Again, you're going to be able to point to a specific matter with regard to litigation. Risk manager, same thing. What is the claim that we're there to discuss? And I think that, if you evaluate it that way, it becomes very easy to answer the question of whether or not we should have an executive session. You always have that specific tie to the executive session. The exceptions are in favor of open meetings and narrowly construed, which again is why I advise always have that specific object. That way folks can never say that you're trying to broaden the executive session. One of the things to always be aware of within executive sessions is what I call executive session drift. And it's very easy to get there, and I will demonstrate it thusly. A board goes into an executive session to consider the filling of a vacancy. As they're evaluating those folks, somebody says, we're filling this vacancy, we've still got 4 other vacancies to fill. Why do we have so many vacancies? Well, because of the recession, our budget got hit hard, and we haven't had the money to fill those vacancies. Well, why don't we have the money in our budget? Do you see what's happened? Now all of a sudden we're way off topic, and it's only 3 very innocuous seeming questions that would generally be very easy to go down that trail. And so one of the keys to an executive session is to make sure you've got folks that can keep you on topic, or somebody that says, hey, wait a minute, we can't discuss that in the executive session. If you want to discuss it, we can bring it up in the open session. So always important to keep that in mind. You also can't, while you're in executive session, change to another topic for executive session if you haven't already gone in for that exception. Now you can go in for more than one reason. And that's why I recommend that you annotate within your minutes that you switch the topic and what time, so folks can follow that. But you can't, while you're in executive session, all of a sudden decide, oh, while we're evaluating this vacancy, there's somebody that I want to bring up for discipline. And that is not a made-up example. That is one that has happened.
Before we move on from executive session, Mr. King?
Sure.
One of the things that's unique to this commission is that we consider information as proprietary to a specific oil or gas company.
Mm-hmm.
And we reviewed that in executive session. Perhaps you could speak to that a little bit for the benefit of the commission?
Sure. And so that information would be, you would go into executive session, if I understand it properly, under D, which are records that are exempt from disclosure. And so what I'm assuming is that you've got records that are proprietary or trade secret information under the Idaho Public Records Act, and any record that's exempt under the Idaho Public Records Act, you have the ability to go in and discuss that record under the open meeting law, under the executive session exception under D of the open meeting law. And the whole point of that is because otherwise it would defeat the very purpose of the public records exemption. And so that's a good example of how those statutes work and play well together.
Okay, thank you.
Sure. You can't make a final decision or take final action within an executive session. And then you do have to have minutes of your executive session. The minutes simply have to reflect that you had the discussion under that exception. I like to recommend that you include the time you started and finished, and that probably meets the requirements for the open meeting law as far as executive sessions. But you do have to have minutes that say you had an executive session and discussed, for example, records exempt from disclosure. So, congratulations, you've made it to enforcement. A couple of things with regard to enforcement. Number one, if you violate the open meeting law, it renders the decision null and void. And what that means is that some action has to be taken. Either the board can say, look, we messed up, we didn't follow the open meeting law, and so that decision is no good anymore. We're going to go back and redo it, or you may decide we don't need to redo it, we're just not going to have that decision anymore. But some action has to occur. Either you as the board have to recognize that you violated the open meeting law, or a court would say you violated the open meeting law and set aside whatever decision that is. It's not something that just operates automatically. If you participate in a meeting that violates the provisions, you can be subject to a civil penalty that is personally assessed, meaning it comes out of your personal wallet, not the board or the commission's public funds. And it's up to $250 for the first violation, $1,500 for a knowing violation, and then $2,500 for a repeat violation. Those fines were just increased in the last legislative session. You may remember that the maximums used to be $50 and $500. And those fines have gotten quite a bit stiffer. The Attorney General has the duty to enforce this with regard to state public agencies of state government. Bad news for you is if you get a phone call from me or someone else in our office, we're the ones that handle that. Prosecuting attorneys with regard to local folks, and then any person can bring a civil action or a complaint with regard to it. The good news is that the legislature allows for boards to fix their mistakes. We call this the cure. And it can occur two ways. You can either recognize it yourself and say, hey, we messed up, we didn't get the notice put up properly, for example, or you can get a complaint from the public. And then you can say, you know what, you're right, we messed up, and fix the violation at that point. And what that does is it stays any complaint about your violation. You won't get fined. It gives you the ability to essentially go through the process of fixing the mistake and learning from it. And we encourage folks to do that. And if that's not persuasive enough, I want to give you two examples. Example one involved the land board. And what happened was the land board had a meeting in North Idaho because they said, hey, we should go out around the state to places where we have these lands and hear from the constituents and interact with them bring the land board to the people, so to speak, good government. Well, they didn't notice the meeting properly. And the Attorney General actually asked the question. He said, hey, are we sure that this meeting was noticed properly before the meeting started? And he got the answer, yep, everything was fine, don't worry about it. Well, the day after the meeting occurred, we got a phone call in our office from the staff, and they said, hey, we didn't notice it properly. What should we do? And so we said, redo the meeting. And so we said, we actually issued a brief press release and said the land board is redoing its meeting of October 3rd because it wasn't noticed properly. So anything that happened at that meeting, we're not taking action on, and we're going to redo the meeting on X date. And here's the notice, here's the agenda for that meeting. It was a complete redo. The news coverage of that was a very tiny blurb in Betsy Russell's Eye on Boise blog. That was it. So that's example one. The land board redid the meeting, everything is fine. Example two was an entity that we got asked to investigate for violating the open meeting law. And so we investigated the open meeting law, and we called them up and we said, hey, we think that you violated the open meeting law. Would you be willing to admit it and do some training with our office on the open meeting law? And their response was, no, we didn't violate the open meeting law. And we said, okay. And so then we prepared a complaint. And before we filed a complaint, we called them and we said, hey, we've prepared a complaint. Are you sure you don't want to just say, hey, we messed up. We're going to get some training. We're going to be smarter on this. Sorry about that. No, we don't want to do that. So we filed a complaint. Front page news. Attorney General's office files open meeting law complaint. And it's not just the front page, because they write the news article, but then who takes the second swing? The editorial page. And so we go to court, and the judge says, yep, you violated the open meeting law, nice fresh run of news. They appealed it. So then it goes up to the Idaho Supreme Court. Again, a nice fresh swing. The Idaho Supreme Court says, yep, you violated the open meeting law. Again, front page news, another round on the editorial page. And so it takes what probably, in our land board example, I think we spent maybe 2 hours between the admitting and redoing and even the press inquiries on that open meeting violation and fixing it. And you compare that to, if you go to the Idaho Supreme Court, that's like a 2-year process. And all through that process, you're giving the press a fresh cut each time something happens. And so I just offer that to you to consider if you ever have an issue where somebody's like, hey, I'm not sure we did that right. Sometimes it's okay to say, hey, we made a mistake, we're gonna fix it. And so just contemplate that. I did create what I thought was a fairly simple chart for the curing process, but I have since received feedback that it's not as simple as I thought it was. The key is that you recognize it, you acknowledge the mistake, and then you take action to address the mistake. If you've got other questions with regard to the open meeting law, we've created a series of checklists. They're all in the back of your manuals. It goes from regular meetings to special meetings to executive sessions. We've got, if you want to know how to make a motion in order to enter into an executive session, as far as amending the agenda, we've tried to create essentially a toolkit for folks to use with regard to the open meeting law so that anything that comes up, we've at least created a process to allow you to kind of think your way through it. If you're wondering if anybody uses those checklists, the answer is yes. The land board uses it every month. And I think they're a good model for compliance with the open meeting law, particularly for the work that you all do. And with that, I'm happy to answer any questions, Mr. Chairman.
Thank you, Mr. King. Commissioners, questions for Mr. King? Thank you. I found that to be very informative. I've been through it before, and a refresher is always good. And I hope to never receive a call from you.
Thank you. And one of the things that I think is always worth reminding boards is that it's important that you do I think it's really important that you take on training like this because it fulfills your trusteeship role within government, and it reflects the fact that you take that role seriously. And so I commend you for scheduling this training, and I look forward to working with you. And again, if you have any questions, I know Christina is more than capable, and she has a direct line into my office as well. So thank you.